scene. Oh, yes, the defense is back at the defense table, I should let you know. And the prosecution is as well. It looks like we're just waiting for the judge to get back up on the bench. I want to bring in Greg Gianforcaro. He is a New Jersey criminal defense attorney, and he's been watching these closing arguments with us. I want to play a little bit more sound, Greg, too, from Attorney Altman on one of the other points he's been making during these closing arguments, and that is the fact, he says, that there were a lot of chances to intimidate Tyler Clementi, his roommate in this case and the victim, but that he didn't do it. Let's listen.
If you wanted to intimidate somebody, if you wanted to put them in fear, and you wanted to do that to Tyler, the opportunities that Darun had on September 19th, there's a lot of people in that lounge. There's a lot of people in that dorm. You've seen them testify. He could have made sure that they were all sitting in that lounge waiting for MB to leave. There could have been people spying in the hall, waiting for the door to open and MB walk out of Tyler's room. There could have been people stationed outside the dorm, waiting. There could have been people there staring, glaring, letting Tyler know that they knew. That might have been successful in putting him in fear and intimidating, but none of that ever happened.
Is that a pretty good argument? Because let's face it, the bias intimidation is what he is most at risk from here. 10 years in prison if he's convicted.
That's right. It's a powerful and persuasive argument. And it's something that the jury will, I would think, would weigh very heavily. The other thing I wanted to say is that is also an argument that a grand jury would never hear. And that's why in certain situations, and in many cases, that's why people who are, just because you're indicted by a grand jury doesn't mean necessarily that you're going to be convicted. Because now you, as the defense, get the opportunity to tell the jury and explain to the jury your side of the story. And I think that's what the defense is trying to say, and that's why it could be a very powerful argument.
You know, one of the other things we kind of all noticed here, and I'm wondering if you notice it too, he talks a lot about Twitter, the attorney does, and I'm wondering, first of all, are we on a different plane when we're dealing with social media, and do we even know how to prosecute that at this point?
Not really, and I'll point out the fact that New Jersey's invasion of privacy statute is only about 8 years old. I mean, when you consider that the laws have been around for thousands of years, an 8-year-old law is is an infant. And I think that as we get more and more into social media, laws are going to have to be changed to reflect that. And that's why you're seeing situations, where people who may have been guilty of crimes that did not exist, which results in new crimes being created. And that's what happened here. That's why there's an invasion of privacy statute in New Jersey in the first place.
How reliable are these tweets and these texts, do you think? I mean, he can't deny that he's not denying that he sent them and that those are his words. And because of that, do you think he should have gotten on the stand to explain his intent?
Well, that's the question that all defense attorneys face, is whether or not to put your client on the stand. Obviously, if your client has a criminal history, you're never going to put him on the stand, or at least it's very unlikely that you'll ever put him on the stand. You're always subject to second guess, and it's not until the jury comes back with a total acquittal that you realize that you made the right decision, because you're always going to be subject to second guessing. And not putting your client on the stand is not reversible error. That's why it's a real hard decision to make. It is the most difficult decision that any defense criminal trial attorney has.
Right, but here are his words, and not only in tweets and in texts, but in an interrogation video with police. Do you think that his age, I mean, he's not a criminal, he doesn't have a criminal past in any way. Do you think his age may have been what Would you have, at his age, at 20, would you have put him on the stand in this case?
I probably not.
Because?
Because of the concern of what an 18-year-old or a 20-year-old might say when they're subject to cross-examination. I think if my client is in his 30s or 40s or even older, then I'd be more likely to do that, because someone that age is more sophisticated to kind of see the perils and pitfalls that a state's prosecutor may try and put him under, or try and throw at him. But in this situation, an 18-year-old, or even, like you said, a 20-year-old, they may not see that coming, and it could totally destroy the trial. So I understand the defense attorneys not wanting to put him on the stand.
Well, and I want to ask you this too, about social media, as we're talking about strategy in a sense. Mr. Altman continues to get up there and he'll pronounce things wrong, or he'll use the wrong verbiage when he's talking about Twitter. And part of you thinks, this is a smart man. I mean, this guy is an attorney. He knows his stuff. Clearly, he would be able, you would think, to understand and reverbalize the correct verbiage for these social media, aspects, especially since he's been studying it and this is his case. Is he doing that intentionally to try to maybe dismiss the notion of social media and how impactful it might be? I mean, what would the reasoning be for not learning those few things? And he gets up there and says, I don't know it, I don't want to know it. Would you employ that same strategy? And what do you think the strategy is?
Well, you've got to understand, if you've got jurors who are in their, say, 30s and 40s and 50s who may not be as sophisticated, if he starts throwing sophisticated terms about social media at them, they may not understand. Whereas if he is as a defense attorney, or is in his 50s or 60s, and the jury is not really akin or sophisticated in social media, he may want to try and put himself in their place and make them feel like he's one of them.
Right, that's what I thought.
It's an
and does it work?
If Darun Ravi's found not guilty, then it worked. If Darun Ravi's found guilty, then it didn't work.
We wait and see. All right. Greg, thank you so much. We're going to take a quick break here as we wait for them to come back for the finishing of the closing arguments.